Hi everyone, and welcome to our webinar on strategies for preparing effective principal and corroborating affidavits in U and VAWA cases. My name is Amy Chung. I am a senior legal counsel at Assista, and I am joined today by our other senior legal counsel, Laura Flores-Bachman, as well as our policy director, Cecilia Friedman-Levitt. We're also very grateful today to have the support of the Office of Violence Against Women, which is providing the grant support for this webinar today. We wanted to have this webinar for you guys because we see a lot of requests for evidence, or RFPs, and filings where people have submitted affidavits. And these affidavits could be for principal petitioners, they could be for derivatives, they could be by witnesses, family and friends, and there can also be sometimes reports or evaluations from medical providers and mental health providers. And reviewing these affidavits, sometimes we've noticed some common issues, which we'll be addressing today. And this webinar is intended to provide some general guidelines and some tips on preparing affidavits for your U and VAWA filing. The objectives for today's webinar are that you'll be better able to identify characteristics of a strong affidavit, to assess the effectiveness of principal and corroborating affidavits, and to guide affiants in writing the affidavits themselves. Now, let's start with the basics. So why do affidavits matter at all? So first of all, they're evidence for your case. Right? So the evidence for your case might include extrinsic things like marriage certificates or police reports and things like that. But the affidavits themselves can also be evidence that support your client's eligibility for the benefit that they're seeking. And in some cases they're required, in other cases they're not. So for example, for T and U visa principal petitioners, they are required to submit a sworn statement with under the regulations with information about the qualifying crime, right? This is a little bit different for VAWA self-petitions and I-751 petitions and waivers, where an affidavit from the principal is actually not required. However, a lot of people do submit these anyway because sometimes there are other reasons to submit an affidavit other than just whether it's required or not, right? So you'll be looking at what other evidence you have and whether or not you can prove your case without an affidavit and whether or not an affidavit would be helpful even if it's not required. It's also important to consider that for these forms of relief, USCIS is supposed to apply the any credible evidence standard. And under this rule, USCIS isn't allowed to require a specific type of evidence, right? They can't require you to provide a specific piece of evidence to prove something. And so if you don't have other evidence, a petitioner's affidavit alone, in theory, could establish eligibility for the benefit that you're seeking. And this can be especially useful in T visa, VAWA self-petitions, and 751 domestic violence waivers because we see in a lot of survivor-based cases don't have a ton of outside evidence, reports and medical reports and things like that that could otherwise prove their case. And so the affidavit becomes extra important. In these cases, you might find that you do need an affidavit or a report from a mental health provider or another department for the substantial abuse requirement, for example, or for the waivers. And, yeah?
I'm going to have you back up just a little bit because your sound went out. So if you could go back, just maybe start the not required part of it.
Okay. Did it go out completely? Because maybe I just need to change rooms because if this is going to be an issue.
Yeah, and so I think that what we're talking about too, and I think this is something that I just wanted to discuss anyway, is when you're talking about the any credible evidence memo, which again is a memo from 1996. It's available on our website. It is by Paul Virtue. It's a pre-DHS INS memo. It is and discusses kind of what credible evidence is. And I think it's important to take a moment to talk about kind of the burden of proof and kind of an evidentiary standards, right? And so it kind of thinking through other applications where primary evidence might be required or secondary evidence would be required. And I think here that Congress, when it created VAWA protections, specifically made this any credible evidence evidentiary standard and expressed recognition of the fact that oftentimes survivors who are fleeing abusive relationships are not going to have access to these primary documents that they ordinarily might have. And so I think, too, just kind of doing some background about like why that kind of is necessary, why it was kind of mandated by Congress, and kind of how it is not only just in memo but in statute, right, that creates this more flexible evidentiary standard to meet the burden of a preponderance of the evidence. Amy, are you back?
Yep, I am here.
All right, go for it. So sorry to jump in there.
Okay. Sorry about the technical difficulties there. Going back to whether or not affidavits are required. So they are required under regulations for U and T visa principal petitioners. There is actually no regulatory requirement that VAWA petitioners or 751 petitioners submit an affidavit with their application, but they can still be really useful for the reason.
So wait.
What?
Amy, I've always done a self-affidavit for VAWA petitions. So you're saying that's not necessary?
It's not required. It's technically not required. But I'm not saying that you shouldn't do it. So there are lots and lots of really, really good reasons to submit an affidavit with a VAWA self-petition or a 751 petition. It's just that it is technically not required by USCIS that you do so. But in many cases, and I would even say most cases, you will find that submitting an affidavit is ultimately going to be helpful for the case. And this really goes to the underlying reason for the any credible evidence standard, right, which is that a lot of survivors, especially domestic violence survivors, are not going to have the types of primary and secondary evidence that USCIS might expect in other contexts. So, for example, to prove good faith marriage, a lot of times USCIS asks for things like evidence of commingled finances and mortgage agreements and lease agreements showing both people's names and things like that. But we know that in the domestic violence context, oftentimes the abuser has controlled finances and other aspects of the survivor's life such that the survivor doesn't actually have those kinds of evidence. And that's really where an affidavit can be extremely important. And then, as Cecilia was saying earlier, the any credible evidence standard does apply to these types of applications, the underlying reason for which is that Congress recognized that crime survivors and victims oftentimes just don't have the access to the kinds of primary and secondary evidence that might be accessible in other types of settings, right? And so the petitioner's affidavit alone can, in theory, establish eligibility as long as they're meeting the other documentary requirements. Okay. All right. So what can affidavits do for you? So in addition to laying out some of the eligibility requirements, they can do a lot of the background, the filling in the gaps, the connecting the dots for USCIS that simply submitting pieces of evidence like bank statements or a marriage certificate might not be able to do. And so in the affidavit, your client can frame the case in a way that is most sympathetic and compelling for them, right? To show their eligibility, to link the events and to link their story together in a way that makes sense as a narrative, so that they're presenting their story really to the officer as opposed to discrete pieces of evidence. You also might have cases where you have outside evidence for some pieces but not for others, and the affidavit can do a nice job of filling in those gaps, right? There also might be times where there have been events that have happened that if the person who's reading, who's looking at the evidence isn't really closely familiar with the background or cultural background of the applicant, if they're not very familiar with domestic violence dynamics, they might be a little confused about how something could make sense. In the affidavit, that's a really nice area or a nice opportunity for the petitioner to explain where they're coming from and provide the background that can give more context to what happened and to the decisions that they made and things like that. There are also other types of affidavits, right? And so oftentimes you'll have people submitting witness or corroborating affidavits for all of these types of applications. And to the extent that they're corroborating what the petitioner, the principal petitioner is saying, they can bolster the principal's credibility, right? You might also have cases where you're submitting character references, such as if you have a discretionary case and maybe the client has some discretionary issues that you need to overcome. So a character reference, if done well, can potentially address some of these discretionary issues and relieve concerns that USCIS might have about your client's conduct and whether they deserve the benefit that they're applying for. And then we also see lots of cases where people have obtained either medical documentation or documentation from social services providers, counselors, case managers, mental health professionals, you name it, in support of their case. And so again, if these are done well, then they can support your client's credibility, and they can also show how your client meets the requirements for the benefit. For example, in U visa cases where your client is trying to show substantial abuse, particularly substantial mental abuse, mental health evaluations can be helpful to show how the qualifying crime would be connected to any mental abuse that your client is claiming and to establish the severity of that, right? And so all of these types of documents, whether they're affidavits by the principal or letters from friends and family or reports and evaluations from other service providers, can support your client's case and also lay out the facts in a way that makes it more compelling for the adjudicator. So when do you submit an affidavit? So as we were talking about earlier, for U visas and T visas, the principal petitioner has to submit a signed statement. And in the signed statement, they have to describe the facts of the victimization. For the T visa petitioner, they also need to describe their compliance with reasonable requests for assistance from law enforcement. You're not limited to these issues in the affidavit, right? So obviously the principal petitioner in both T and U visas has the option of describing other things in their affidavit as well, including substantial abuse for U visas, including physical presence and other issues for T visas. Really, whatever eligibility requirement is at play for the petitioner can be included in the affidavit. So there isn't really a limit to what you can include. I would also flag here that the requirement under the regulations is for a signed statement. Sometimes we get questions about whether things need to be notarized. Under the regulation, there is no requirement that these statements be notarized. You can certainly do it. There could be arguments that notarization could increase the reliability of the document or something like that, but you aren't actually required to do that. And so there are lots of times when it doesn't necessarily make sense to go through the trouble of getting something notarized if you don't have to. When else might you need to submit an affidavit? So for volatile petitions, as we were talking about, they're technically not required, but they can be really useful for showing any and all of the elements for a volatile petition eligibility, including good faith marriage, battery, extreme cruelty, and good moral character. And if your client is inadmissible, then the affidavit is also a good spot to talk about any inadmissibility waivers that the client is going to need in order to adjust status. And then for 751 waivers, especially DV waivers, likewise, they're not required, but they're still going to be useful for showing good faith marriage and battery or extreme cruelty. Format. So there are really not a whole lot of requirements when it comes to format, which is why I think you see so much variety and variation in terms of what people submit to USCIS. And it's really a judgment call. Some people have done their affidavits in a certain way for a very long time, but there aren't rules about this, right? And so the idea is that you're going to format it in a way that is going to make it easy for the adjudicator to read, and that is going to flow narratively in a way that is going to make it easy for the adjudicator to understand, right? And so just try to think about it from the perspective of the adjudicator when you're formatting an affidavit. They do need to be signed, right? As we were saying earlier, affidavits technically would be signed, declarations, notarized. Declarations don't need to be notarized, sworn statements don't need to be notarized, so it's an option that you have if you wish to. Numbered paragraphs. So some people do their affidavits as one very long story without paragraphs, or at least without numbered paragraphs. I'm generally a fan of numbered paragraphs, the reason being that I think it helps for organization, and also because in your cover letter, as you are explaining why your client is eligible for the benefit, it's really helpful to be able to cite to your exhibits to show what evidence you've provided for each of the eligibility requirements. And if you're citing to the affidavit, you can cite to exhibit X, whatever it is. But it's really helpful to be able to cite to the specific paragraph that is talking about the thing that you are talking about, right? And especially if the affidavit is relatively long, then numbered paragraphs can be really useful to point the officer to what you're talking about. Some people also include thematic headings within the affidavit. They might group the paragraphs by time period or by eligibility requirement. Either is an option. Headings generally are optional, but they can help for organization. And also putting in the headings can even help you to figure out whether or not your client has addressed all of the things that need to be addressed in the affidavit. And then for readability's sake, you'll want to, I would encourage people to put some spaces between their paragraphs and keeping their paragraphs to a defined topic, right? And so it just helps the reader along as they're going through the affidavit. All right, and Cecilia, you are up for what an affidavit should contain.
Thank you, Amy. And I think that the next few slides kind of talk about affidavits from both a perspective of principal applicants, but also supporting declarations. And so we're going to kind of talk about affidavits and these declarations kind of collectively before breaking down kind of a little bit more details about principal applicants and then supporting declarations and affidavits. And I find that these statements, and particularly the statements and declarations of principal applicants, to be the heart and soul of these applications. And because that it is the survivor's own story, told in their own words and in their own voice, and we're talking about any credible evidence And to my mind, that credibility is built on authenticity. It is this person providing information that is trusted, that is believable? And so that's why saying things like, I was subject to battery and extreme cruelty, is not going to be sufficient in order to meet that any credible evidence standard. So first and foremost, whether it's a principal applicant, whether or not it is someone who is writing to support an element of the case, being their own words and their own voice is critical. And so that said, right, you know, the factor of kind of how this is done is dependent upon a lot of different things. For example, what you're a survivor's or the person's literacy and education level might be, what their capacity to dedicate time to this process outside of their meetings with you. And so a lot of kind of what the process is depends on a lot of different factors in how the survivor is most comfortable proceeding. Maybe they're working with an advocate who can help walk through this process. And so generally, when we're talking about the role that the attorney or the accredited representative or an advocate can play, first and foremost is to go through the requirements of the application, to go through the requirements of a VAWA self-petition, of a U visa and a T visa, and explain the topics that you'll be asking about and why. And so when you kind of dive in, you're just like, tell me about your relationship. It can kind of be a little bit jarring, but if we kind of preface and frame those conversations like Amy mentioned, saying, you know, when we're applying for this type of benefit, what we need to show is that you entered your relationship because you intended to build a life together. So my first questions are going to be about how you met your partner, how you started dating, and then kind of where, you know, how you got married and things like that. And the second element is, you know, the abuse that you suffered. So I'll be asking questions about certain events that happened. So explaining not only what you'll be asking about, but why is, I think, critical to framing and giving people a roadmap to the types of things that you're going to be discussing. And sometimes this might take multiple meetings. Amy and Laura, how many meetings sometimes would it take you to go through a declaration or an affidavit for a principal applicant?
Well, this is Laura. I think it just depends on the individual client, right? How long the history of abuse would probably affect, you know, the client's ability to go through the details of, you know, each traumatic experience or the traumatic experiences necessary to be able to explain to USCIS the relationship. So generally speaking, it's just going to depend on the client, not only their mental health, but then also things like their education level, and maybe their, you know, the initial creating of an attorney-client relationship, right? Getting their trust to such an extent that they can provide you with the necessary details, which are, of course, so personal. All that to say, more than one appointment, right? I would say on average I usually have 2 or 3, and the length of each would vary, yeah.
Right, and I think you bring up 2 points that are really important, and one is that telling a story about their experience is an extremely traumatic process. And that's why I think building that trust is so critical, and that's why the framing is a part of it, right? It's to set the expectation of what is going to be done and the reason behind it is, I think, a trust-building part of this process, but also to kind of take the lead from the survivor on what would help in being okay with taking breaks and being okay with saying, you know what, we don't have to talk about this now. We can talk about something else and get back to it later, or just come back at another date. Or take their, you know, sometimes if they would rather write it down and then kind of go through it, and you can just ask questions about certain points that need clarifying. So I think the approach and how you take is going to be really important in order to do this in a trauma-informed way. Amy, do you want to? Or Laura?
Oh, no, I was just going to agree with that in terms of the approaches. I think I usually probably take both approaches in a hybrid way, right? Maybe help the client draft the affidavit, but then at the end of that first session, I might say, okay, the next time, why don't we plan on talking about X? Would you prefer to draft that on your own, come in, and we can go through it together? Or do you want to just think about it and we'll go through some, you can tell me what happened. So I think it's a hybrid approach, and like you said, take the lead from your client.
For me, I think that for principals, I have generally leaned towards having them come in and then interviewing them over several sessions and doing it together that way. Probably because a lot of my clients didn't feel comfortable writing themselves, right? And so it made more sense to do it together. I think it's a little bit different when it comes to supporting declarations from friends and family who oftentimes weren't able or willing to come to the office. But even in those, and certainly, medical providers and mental health providers weren't coming into my office. But I think even in those situations, I've always tried to at least talk with whoever was going to be writing the declaration or the letter, or provide them guidance in some way about what kind of information was we were looking for, right? Like what is the purpose of the document that they're going to be preparing.
Right, and I think that's true too, and I think something that we have on our website, which I think can assist in particular for advocate declarations and declarations of supporting, particularly I think domestic violence or victims of crime advocates, is to not provide samples, right? Because I think we want this as much as possible to be their own words and their own experience, right? So oftentimes we recommend that they have kind of a paragraph about their credentials, a paragraph or more describing what the survivor said about what they experienced, both kind of the crime itself and how it affected them, right? And then the paragraph explaining about how what the survivor relayed was credible given their expertise and experience working with survivors of domestic violence, right? And so I feel like even when we're talking about supporting affidavits and declarations, it is just as important for credibility that they be in their own words and kind of based upon their own kind of experiences of working with survivors and working with this particular client in general, or specifically. I do have one.
I do have one question, Cecilia, and for Amy as well. When we're talking about putting affidavits in the client's own words, what do you guys prefer to do? Do you, if you're talking about a client whose primary language is not English, do you prepare and have the client sign an affidavit in the client's primary language and then include an English translation? Or do you prepare the affidavit in English with the client's signature and an interpreter certification indicating, that they read it to the client in their own language prior to signing? What is the preference, or is there, or is it, either or? What do you guys think?
I think both are fine.
Yes.
My gold standard has always been to do it in the language of the client, which is easier said than done if you don't speak the language of the client, right? But if you can prepare the affidavit in the client's own language and have them sign that version and then translate it into English, I think that is better for the protection of the attorney. because when you have the declaration only in English and the client is signing that one, and then you have the certificate of interpretation, there's always room for a question about how good that interpretation or oral translation was.
Right.
Yeah, I think that's an excellent point.
Right. But I think that, both have been done, in terms of having that signature at the bottom, not only kind of saying that the person understands that this has been translated or read in the person's primary language, and that they understand the contents, and, swear under the penalties of perjury that its contents are true or correct to the best of their belief, right? So I think that, but I agree with Amy in terms of the gold standard in these cases. If we can move to the next slide, please. So here kind of we talked about how, it is the burden on the applicant to show that they are eligible for the relief they are seeking. And so that is why kind of when we're talking about organization, typically I would organize a principal's affidavit chronologically. So if I were working on a VAWA declaration, I would kind of start talking about maybe a little introductory paragraph, then kind of go into how they met their partner and how they started dating, a little bit about their marriage, and then kind of go into joint residency and good faith marriage, and then the abuse, and then kind of end up on good moral character. But I would try to organize that, I think, chronologically. And when we're talking about, particularly I think supporting affidavits, it is critical that the person's declaration or statement be focused on what it is that they know. All right, so if I am, writing on behalf of my friend who's applying for a VAWA self-petitioner, right, but I don't really know much about kind of the abusive situation, but I introduced them, or I were over their house and kind of saw them together as a couple, right, then I can kind of focus my declaration and focus my statement on that joint residency or on that good faith marriage, right? I don't have to know all the things, but what I can write of and provide detail about is relevant to the thing that I am trying to prove. So I think things I can kind of say that, I saw them together, they would go out to dinner at the same restaurant every Friday, and they would come over and do things with us, and I would kind of provide those details to support that they intended to establish a life together at the outset, and that the relationship was not purely for immigration benefit or relief, right? And I think similarly kind of talking about abuse. And so how is it that I know what I know, right? So even though a person who might not have witnessed the abuse, but maybe kind of talked to the survivor while they were going through it or after they experienced it, kind of talking about the conversations that they've had, talking about their demeanor, about what happened next, about what they said, and providing that detail and providing it in their own voice and saying, I know that, my friend's spouse was abusive. That's not helpful, right? And so I think, what we have here on the slide, I saw them crying. There was a mark on their face. I asked what happened. I said maybe we should go talk to somebody. So explaining a little bit of the details of the requirements of what it is that they're kind of being brought in to help support in their case. If you go to the next slide, please. And I think here, too, is including details that are unique and particular to your client's experience, right? And making it seem like it's not just this cookie-cutter declaration, right? And sometimes you might need to ask about additional details, right? They said while they were dating, they went to the movies. Well, do you remember what movie you saw? Do you remember who was there with you? Do you remember what you did afterward? Right? To try to get a little bit more of those details to kind of make it unique to the client. I think it's important to kind of individualize the survivor's story.
So Cecilia, earlier you mentioned that sometimes you include an introduction, and I've seen a lot of affidavits for all these types of applications where people include like really lengthy introductions about their family, their childhood, how they came to the United States, and things like that. Should people keep doing that?
I mean, I think it depends, right? I think you don't want to overly complicate a declaration, but I think you would focus on the most important thing in these declarations is to focus on the elements that are relevant to what it is that you're trying to prove, right? But I think that some of this background information can be relevant to those requirements, right? If someone suffered abuse in their home country, right, that might kind of explain maybe somebody's reactions or what they might kind of have experienced going forward, right? If this is kind of compounding trauma that they've already experienced, right? Or, for example, if people have experience contacting the authorities in their home countries, why that might explain their reluctance to do so in this particular situation of domestic violence, right? So I think it's a strategy call. Generally, it's kind of an introductory paragraph that says, my name is X. I was born on this date in this place. I arrived in the United States at this date and this point of entry. I came on this type of visa, and I have 3 children who are X, Y, and Z. Sometimes it's just as simple as that. Whether or not you want to include any other family background, what happened, and if there's any kind of details of what happened when on their journey to the United States, I think I would gauge that as what relevance does it have to the elements that you are trying to prove in the underlying case. Any more on this, Laura, Amy? And I'll just move on to the next slide. Okay, so I think, yeah. All right, so I think this kind of really dovetails well. Is what should affidavits not contain, right? And the most important thing here, right, and I think this goes back to my my favorite 1996 Paul Virtue memo, and I will let Laura and Amy tell me what their favorite memos are later. But I think that here, what you are checking for here in terms of the details you're providing is consistency, right? In this memo that I talked about, it says that evidence that is inconsistent with other elements of the case or with other evidence in this case is internally incredible. So I think you need to be including details and that are, again, relevant to the claim. And again, as we mentioned before, if it's not relevant, what other kind of, is it helpful in another way, right? Does it explain the survivor's motivations? Does it show their point of view? Does it provide background on why they did or did not take a particular course of action? And so here, I think it's important to kind of check the declaration against other evidence you have in this case. For example, and if there is any inconsistency, so if a client's declaration does not kind of match up with a police report or a medical report. For example, you might have a police report that says that there was physical violence, but not mention anything about a sexual assault that occurred in the same day, right? What might be a reason that the survivor did not feel comfortable disclosing to the police the sexual assault? And so and kind of explain that in the declaration. You'd be like, this is not something that I was just too traumatized that I did not feel comfortable because I didn't, for one reason or another, talking about this to a male police officer. So if there is inconsistency, the first question you need to ask is it material? If it's not material, then say why it's not material. But if it is material, then explain to the best that your client is able what it is that kind of is the reason that one thing might be different than the other. And so I think looking at these after you write the declaration, comparing it with other things that you are using to support the case is incredibly important. And again, I think that this is obvious, that don't use things like substantial abuse or good moral character or extreme cruelty. Again, these might be kind of headings that you use in the affidavit, but it shouldn't be kind of part of what the words that the survivor is using to tell his or her own story. The limited exception is if you or another attorney is providing a affidavit. And so this is kind of, I think, a very limited circumstance in which they might be happening. For example, if there was a prior attorney error and the attorney is submitting a declaration to explain that error, or if an outside attorney is acting on an expert on a particular matter, then I think one would expect terms of art to be used in those affidavits, but otherwise they should not be used. But I think that when you're talking about a medical professional who is submitting an affidavit, you're kind of talking about their expertise, and kind of they would also use, I think, their own jargon in putting that forward. If we go to the next slide, please, 12. We talked about how it is required for principals and UNTs to provide an affidavit, optional, but often I would say in 99.99% of the cases are probably submitted also for VAWA self-petitioners and 751 domestic violence waiver petitioners, although it is not required. We're talking about affidavits for derivatives. I think this is often done in case, for examples, where a derivative might need to submit their own 192 for inadmissibility waivers and might need to include an explanation of a certain events that occurred related to their waiver that they might also need to, or they could submit affidavits relevant to explain what it is that they've witnessed in the principal's case, right? If you have a derivative who'd be wanted to write a supplemental or a supporting declaration for parents' self-petition, kind of what it is that they know and how they know it as well. But again, we talked about how witnesses, what they can corroborate one or more elements of the case. And again, I think something that's really important here in terms of service providers is kind of what other, when we're talking about, I think we're going to talk about in the next slide, kind of systems evidence. So if your client reached out to other systems and institutions for help related to the abuse, then trying to connect with those people to see if they can submit supporting documentations to support that they were in fact contacted for help in the situation. And we can go to the next slide. So again, we talked about how they have to address the topics required by regulations. So if you look to kind of the T and the U visa, kind of talking about how they were a victim of crime, the substantial abuse they suffered due to their victimization, the information that they had. So I think that go through the regulations and make sure that you are addressing all topics that the declaration is supposed to address. And then again, when we're talking about systems evidence, as I mentioned earlier, what other institutions or services were involved in this case? Were there police reports? Were there medical reports? If we're talking about good faith marriage, right? Are there leases? Are there taxes? Are there bank statements? So evidence that are kind of provided by an outside source to show the elements of what it is that you, elements of the case, right? For substantial abuse, for good faith marriage. And again, you should use the declaration to explain any missing evidence or a lack of evidence. So for a VAWA self-petition, were there police reports? And if not, why not? Are there medical records? If not, why not? If there aren't any joint bank statements, why not? And that might be due to the fact that the abuser did not let the survivor have control of any financial resources. Why aren't there any photos of injuries? Why didn't they reach out for help from a counselor? So to explain if there isn't this systems evidence, why not? Or for example, and if things aren't available, then what for police reports, for example, then explaining what it is that they tried to do to get that documentation and the efforts that they made to try to get a document, but it was not available. And I think here, in the next two slides, we have two statements, and we want to kind of see which is more convincing. So the first one says, X and I lived together on and off for 8 months. We didn't have enough money for our own place, and so we bounced around to different relatives or friends' houses, and there was a couple weeks we were at a motel. Versus, X and I lived together on and off from January to August 2018. We didn't have enough money for our own place, so first we spent about a month and a half at X's mom's place at this address, and we were living in her basement apartment. It was set up as a separate unit with its own kitchen and bathroom and a separate entrance, and so it was like we were living on our own. But then we got an argument with his mom, and she kicked us out. After that, we went to my friend's house and crashed on her couch for a week, but it was uncomfortable because the couch was just in her living room. We didn't have any privacy. And so I think here, what are the details that set these two statements apart? Amy and Laura, do you have anything that kind of jumps off that just like, why is the second so much better than the first?
I think in this kind of case where you know that the self-petitioner and the abuser live together on and off for a relatively short period of time, it sounds like they might not have a lease together based on these details. They probably don't have a mortgage, right? So you might not have those kinds of pieces of evidence from outside institutions to establish that they live together. And so I think the details about specifically where they were with the addresses and when, the time periods, but then also the idiosyncratic details about like what the basement apartment looked like, how the couch was situated and things like that. That level of detail lends a little bit more credibility to the account.
And I think that's clutch because what we are seeing now in terms of RFEs, particularly I think on good faith marriage, is that USCIS is looking for details about your daily routines, of what the marital home looks like, and to show the dynamics of the relationship, you know, prior to your marriage, during your relationship. And so I think that they are looking for that kind of idiosyncratic detail about what it was like living together, the daily routines. You know, my partner went to work at 8 o'clock and I went to work at 7. So those are the details I think that they are really more and more looking for. Now we're going to go on to the next slide, on slide 15. Again, two statements. I got a protection order to keep X away from me and the kids, but the day after, X tested me and said that he wanted to talk. I was scared about what he would do, so I called the police and they arrested him. Versus, X had attacked me many times during our relationship, and once he gave me a black eye for asking him not to drink so much. Another time, he grabbed me by the hair and dragged me out of a party because he thought I was flirting with someone else. He always told me there was nothing anyone could do to stop him. When he violated the protection order, I thought that maybe he was right, but I hoped that the police would finally help me. Now that X can't get to me or my kids, I feel safer, but I still have nightmares about him, and sometimes I think I see him at the store or on the street, even though I know it's not him. again, what is it about this second paragraph that makes it so much more convincing?
I think, generally speaking, it's that it sets up the story, which is what Amy was talking about earlier today, is that you want the client to be able to tell their story so that the officer who's adjudicating the application can understand, can have a frame of reference for what was going on in the petitioner's life. And I think, the second example that you just read does exactly that, right? It brings to life what your client was going through by including some of her feelings and why she had those feelings.
Right. And I think that's a really important point. I think especially if you are writing an affidavit for a principal VAWA applicant, maybe based on more of extreme cruelty. And I think those kind of details is not only kind of maybe it insults that the abuser would say or kind of the isolation tactics that would occur, but how that made the survivor feel, right? Those details about reactions and actions, I think those are the important details, right? And kind of showing the extreme cruelty was not only the action itself, but what was the impact of the action on the survivor, I think is really important details in those types of cases. And so now I think that, Laura, I am turning it over to you.
Okay, great. Let me move on to the next slide. So we're going to be talking about corroborating evidence. So when you're talking about supporting your client's statements, the information that your client is putting forth in an application, as Amy mentioned before, there will be times when any credible evidence will come down to someone else's affidavit rather than what we think of as systems evidence like a doctor's report, for example. So when we're looking at corroborating evidence, that's going to be the first question, right? Is it helpful to your client's petition or application or what your client is trying to establish with this affidavit? And so in order to determine whether it's helpful, we first have to look at whether the affiant will have or have had first-hand knowledge of any facts that are relevant to the eligibility requirements. Okay, so first-hand knowledge and relevance. And so in order to determine that, we have to look at what is first-hand knowledge. So first-hand knowledge is that they saw something or heard something themselves, okay? They were there, they were present and saw or heard the event that they are going to go on to describe. And so if it's not first-hand knowledge, then you want to know, okay, is it still relevant? And in order to determine that, you want to know more about the details of how did they find it out. So, for example, a time where it might not be first-hand knowledge but still relevant is in the situation where maybe the petitioner, VAWA self-petitioner, for example, calls her brother immediately after she escapes from the abuser to ask him for a ride, right? And he can hear in her tone that she's scared. She provides him with details on what exactly has happened. She maybe provides him details about where the incident took place, why she's afraid, why she's fleeing, those details that perhaps he was not present to witness, but the phone call to him took place immediately afterwards, and therefore he can corroborate what the self-petitioner said in her affidavit in describing the abuse. He can then say, yes, she called me immediately afterwards. She was scared. This is how I know she was scared, etc. Okay, so you determine that it's relevant. You determine that they have firsthand knowledge, or if it's not firsthand knowledge, it's still relevant and helpful. So what should they explain? I usually consider these the reporter's questions, right? Who, what, where, when, why, and how, right? So who they are, how do they know the principal, how long have they known the principal, and here it's the principal applicant or the petitioner. So how long have they known them? How do they know them, who they are, so their relationship to that petitioner, whether it's friend or family member, in this case that I just gave, the brother, right? And then what they know in as much detail. And when they're describing it, of course, you want to make sure it's relevant. And then how they know it. And then you also want to ask when, right? So make sure when they're explaining the information that they give some kind of time reference. Here it's kind of important to think of consistency as well. I think it was Cecilia who was talking about other affidavits and whether it causes some inconsistency in what the self-petitioner has said or what your client has said. You want to look at that here as well. So while you want your corroborating affidavit to also include when, a time frame for the event, or maybe a time frame for how long they've known the person, always go back to your own client's statements, because oftentimes, it may still be consistent, but maybe the brother or the self-petitioner don't remember the exact date. For example, she called me right after her birthday party. It was May 7th. But then the petitioner says, I called him right after my birthday party. I had turned 26 on May 9th. Okay, so there's two different dates there. And then first you want to get, okay, when is her actual birthday? Did the party take place on her actual birthday? So those are some inconsistencies that may be very easily dealt with, but you've got to make sure and catch them and just, ensure that that is explained in either the affidavit or in the information that's submitted by the petitioner. Very easy inconsistencies that are also very common, right? Sometimes we don't remember exact dates. So another way to look at this too is if you're trying to put it in a frame of reference, think of time in a different way. Maybe think of a season, or if it's describing someone who's still in school, then maybe they would think of it in terms of a school semester. So you can still reference time and add to that add that extra detail to give the affidavit credibility, but not, boxing your client into a date certain that he or she may not remember. Okay, so go to the next slide here. We'll give you an example. What's more convincing? So this is a good faith marriage requirement that they're trying to corroborate with the affidavit of a friend. So the first example, Susie and John were a perfect couple. They were very happy together, and I know Susie loved John very much. I was shocked to hear that John had been treating Susie badly. I know Susie married John because she wanted to be a family with him. Or, I heard about John around 2007 when I was visiting Susie, and she told me she had started seeing someone new. Susie seemed giddy when she told me about him and was smiling the whole time. She later introduced me to him at a friend's party, and I thought they seemed really happy. They stayed close to each other the whole night and were holding hands. When Susie told me they were getting married, she said she was excited because they had talked about having a child soon. So I think the difference between the two, right, it's almost the same information, but the second example is giving you the full context, is answering those reporter questions, right? Who, what, when, where, and why. So she first heard about him in 2007. Well, where did she hear about him? Well, she was in a party. And how did Susie seem? Well, she seemed giddy and she was smiling. Okay, all of those little details, set up the information in such a way that it's clear that that person who was hearing those details had context, right? So that she's not just verifying something that Susie later told her, right? She was there at the party, met him as her friend, was introduced to him. It's different from I knew they were together, right? It's not really answering, well, how did you know they were together? So this is a good example of why, even though there's seemingly small details, like Susie seeming giddy, why is that important? It goes back to showing why she intended to be married to him. She was happy. She wanted to be in this relationship. And then they also talked about having a child together. So those two things get to, was this a good faith marriage? Whereas in the first example, you don't really get those details. She just says, I know Susie married John because she wanted to have a family. Well, how did she know this? And how did she know Susie's intent, right? There's not enough there to provide the adjudicator with enough information to give real weight to this particular affidavit if you're going to, if it's not going to include sufficient information. Okay. So let's talk a little bit about character references. Sometimes attorneys might want to include a corroborating affidavit in order to provide character reference, right? So the affiant says things, the petitioner may say something in her own affidavit that says, I'm a person of good moral character, I've never been arrested. Okay, that's good that you say that about yourself, but in some cases it might be helpful to have someone else say that about you, particularly in cases where there's a discretionary component to the adjudication. For example, in a VAWA self-petition adjustment of status, where under INA 245A, it specifically says the Attorney General may adjust the status in his discretion, right? Same thing with a T visa waiver or a U visa waiver. It's in the discretion of the adjudicator, in addition to the other requirements when adjudicating that particular application for a waiver or that application for adjustment of status, for example. So in those cases, it might be very helpful to be able to obtain character references in order to corroborate the self-petitioner's own statements of the evidence. So you're still going to want to include those reporter questions, right? Who, what, when, where, why. But in this case, you want to focus on contributions to the community, helpfulness to friends and neighbors, the role of the petitioner in supporting their family. If the person that's writing the affidavit is aware of, for example, in the case of an inadmissibility waiver, so if the person writing the affidavit is aware of the person's criminal history or aware of the person's immigration violations, that's helpful. And the reason it's helpful is because they can say, I know that petitioner did this, committed this crime in the past. However, even knowing that, this is why I think they are still a person of good moral character or still a person deserving of the waiver of inadmissibility, right? Whereas a person who maybe doesn't know that history and is just giving their glowing remarks, the adjudicator might say, well, would they still give such a glowing recommendation if they had known about the petitioner's criminal history? You know, I think it may leave that question in the adjudicator's mind. Now, with civil immigration violations, perhaps that's not as big an issue. It's going to depend, you know, case by case. You make that assessment as to whether it's important to include that detail, whether it's important for the affiant to know that history. So let's look at an example of this. What's more convincing in this case? So the person is providing a character reference and says, Monica is a respectable woman, a good friend, and a loving mother. I can honestly vouch for her good character, and I hope USCIS grants her a green card. Okay, in that example, she says all good things, right? She says the person is a loving mother, a good friend, and a respectable woman. But she doesn't say how she knows this. She doesn't say why she's able to vouch for her good character. She says she can honestly vouch for her good character, but not why. There's no frame of reference. There's no setting up and explaining to the adjudicator who's, you know, does not know this affiant, right? Doesn't know the history between the affiant and the self-petitioner or petitioner in this case. And so without that background, it's a little bit difficult to know. I mean, it's good that they say she's got a good moral character, but it's difficult for the adjudicator to give it a lot of weight. So compare that to, I've known Monica for 4 years. We met when we lived in the same apartment complex, and our daughters attended the same school. I often saw Monica tidying up the building hallways and sidewalk around our complex, even though she was just a tenant and no one was paying her to do that. I also saw her waiting at the bus stop every morning with her daughter, and her daughter always had her hair braided and her clothes neat and clean. Monica told me that she had to work 2 jobs to support her daughter, but she never complained. So this sets up that picture, right? You can actually visualize them, you know, maybe at their apartment complex. You can see Monica, you know, being helpful around the apartment complex and the other tenants appreciating that. You can see them waiting at the bus stop together for their daughters to return from school. You've set up the picture in such a way where you might say, okay, this person knows Monica. She's known her for 4 years, and in those 4 years, she has only known these good things about her. You know, 4 years is a good amount of time to know her, and it seemed like she knew her and knew some details about her life from first-hand knowledge, right? So this explains who the writer is, a friend of Monica. It explains how they know the applicant. They met at the apartment complex and became friends. It explains how they know that Monica is a person of good moral character. This person saw Monica tidying up, saw Monica, you know, taking care of her daughter, you know, talked with Monica about her 2 jobs, right? Those are all first-hand accounts of what she is trying to explain to the adjudicator through this affidavit. So the important thing here is, of course, and in this case, this paragraph does stick to the relevant facts, right? You don't want to go too far off in terms of giving a lot of details. So you're always looking at, is this relevant to your client's case? Is it going to be helpful? So relevance and helpfulness, enough detail. And in this case, I think the first paragraph, the first example, probably not going to be helpful, right? What did it really tell us about their relationship? And so if we look at those 2, I think it's the second one is just a little bit clearer in setting up the picture and allowing the adjudicator kind of a window into why Monica is a good person, is a person of good moral character. Now let's switch gears a little bit when we're talking about other types of affidavits that can corroborate the client's own statements and own application. So reports from service providers will oftentimes be extremely helpful. They are professionals, they are experts in their field, and when they have had direct contact with your client, an affidavit from the service providers could be very helpful. The most common might be a mental health provider. The first important point we put here at the beginning is mental health providers do not need to be psychologists. This is important because we have had questions about this where an attorney or an advocate might not know whether a domestic violence counselor who is not a psychologist, whether that would still be relevant or helpful. And the answer is yes, of course, it would be relevant or helpful. It's important to explain their expertise, just like you would a psychologist, right? Their training and expertise in psychology would be a psychologist's purpose in being helpful to your client's application in showing what they may have suffered. But by the same token, a professional domestic violence counselor will also have training and expertise in assessing domestic violence, in assessing the mental health of a domestic violence victim, and could certainly provide a lot of context and professional assessment that can help the self-petitioner establish a objective assessment of their mental health, an objective assessment of what they suffer being domestic violence, right, being found to be domestic violence. So in order to provide a helpful affidavit, you want to start first with have it on letterhead. Why is that important? You want to show where the domestic violence counselor works and what their title is, you know, just basic facts, but you also want to give the adjudicator the ability to contact that counselor. Now, I just want to say in my 3 years that we are, almost 24 years of practicing law, I have never had an experience where an adjudicator picked up the phone and contacted the counselor, but you want to give them that ability to do so if they wanted to, right? Chat with the counselor about why they provided that affidavit. So having it on letterhead, showing where they work, they can be contacted, their address, their phone number, etc., is helpful, and that they are, you know, working in their field of expertise. So maybe the letterhead is from a domestic violence shelter, as an example. The letter itself should start with explaining, just like for other affiants, start with explaining who they are, right? So if they are a domestic violence counselor, you want to talk about what their training was in becoming a domestic violence counselor. So what their training is and what their particular expertise is. Do they work with victims of sexual assault, for example, or do they work with child victims of domestic violence? Whatever their expertise is, have the counselor start with that so that the adjudicator can easily see, oh, okay, they have experience in doing this. They have had, 7 years working at this shelter. They know what they're talking about. And their job title tells me that this is what they do. So the letter that she's providing, talking about the victim having suffered domestic violence and talking about the mental health of the victim, makes sense to the adjudicator. You also want to get into how they assessed the petitioner, right? So maybe they talk about the number, the type of assessment that they normally do, what that assessment includes, whether it's particular questions, whether it's a certain type of interview. And so they said, this is the type of assessment we do, and I did this assessment with the petitioner. And then they can summarize the facts that support that assessment, explain why those facts show that domestic violence took place or show that mental abuse was suffered, and explain any diagnosis or treatment. So diagnosis and prognosis and treatment, right? So what did the victim suffer in terms of a mental health diagnosis? For example, if they want to say the diagnosis is post-traumatic stress disorder, and how they are treating it. Well, we expect her to make, good progress. We're hoping, with maybe counseling, maybe group sessions, whatever the counselor feels is the treatment. And if your client has taken advantage of getting treatment at the counselor's facility, can include that as well. So what you should not include, and this is kind of important, is, the counselor may think they're being very helpful by saying, obviously, the treatment that she has access to here, she wouldn't get in their home country. Well, unless the counselor has firsthand knowledge, we're talking about firsthand knowledge being the best type for having a corroborating affidavit. So unless the counselor has firsthand knowledge about conditions in their home country, it really shouldn't be included here. It won't be as helpful as the counselor may feel it will be, because that counselor's expertise is in domestic violence counseling, right? Their expertise is not in the mental health services or treatment in El Salvador. So we don't want to get off track and inadvertently undermine the counselor's report by including facts that may not be within the realm or scope of their expertise. Okay, so I don't know if Amy or Cecilia, you have anything else to add before we kind of wrap it up and go into our takeaways. Having heard nothing.
No, I don't think so.
Okay, so we'll get to our takeaways. We've talked a lot about different types of affidavits today. The main thing is quality over quantity. And that means quantity of the number of affidavits you submit, but also quantity of the facts, the number of facts that you actually put into your affidavit, right? If they're not relevant, then don't put them in. It's not necessary. Affidavits should be in an affiant's own words, and Amy went into detail about that, and so did Cecilia in talking about the self-petitioner or the applicant for an immigration benefit. But it's the same when it comes to a friend, a character witness, or a professional assessment. You want it in the affiant's own words. So the attorney or advocate should be helpful in getting the information out, but not in putting it in the attorney's own words. Affidavits should focus on eligibility requirements and discretion, and fill in the blanks from systems evidence. So again, going back to the any credible evidence standards, the purpose of these affidavits is to fill in any gaps. So if the survivor is unable to get a particular document like a police report, that these affidavits are meant to fill in those gaps. They're meant to help the petitioner meet that standard And so before you decide on whether or not you're going to submit it, ask yourself that question. Is it meeting an eligibility requirement or discretion or filling a gap? If the principal is submitting an affidavit, the adjudicator should be able to read the principal statement and understand why she's eligible. So in other words, if the principal is, in their own words, including information, it should, going back to what Amy and Cecilia mentioned, tell the story at the same time, using that story to tie into each of the requirements of eligibility. Okay, so when you're preparing these affidavits or when you're reviewing affidavits that have been provided to your client as support, go back to these takeaways from today so that you can determine whether it's going to be useful for your client's case and really help to get your client to meet those eligibility requirements.
And then the other one that I forgot to include on the slide, but which both Cecilia and Laura mentioned earlier, is consistency. So whenever you get an affidavit or a supporting declaration from a witness, a friend or family member, a mental health provider, and also your client's own affidavit, compare those against each other and also against whatever other evidence is in the file. Make sure that you're not introducing red flags.
That's an excellent point. Thank you for going back to that one. Yeah, absolutely, and that goes across the board for any piece of evidence you're submitting, but particularly when you're trying to get the adjudicator to give weight to an affidavit in lieu of other documentary evidence. So yes, thank you, Amy. Thank you guys so much for joining us today and sitting in on this webinar dealing with affidavits. As always, if you have questions about your particular case and whether an affidavit would be helpful, you can contact us through the individual technical assistance through our website at the link provided here. And you can also look for additional helpful information on our website or join one of our listservs. We have a U visa litigation listserv, a VAWA experts or assist to experts listserv, and a VAWA updates listserv that lets you know about upcoming webinars or other events that we have going on. Thank you to Cecilia and Amy, and we will see you guys next time.
Thank you, Laura. Thank you, everyone.
Thanks, everyone.